this talk really is to identify and define the most common issues that are relied upon, go through the notice requirements, examine the court's powers and procedures, explore potential defences and tactics, and lastly talk about costs. The reason that this talk is becoming more prescient is because there has been, certainly anecdotally within Chambers, and I know from speaking to a number of you as clients, there has been a massive increase in the last few years in the number of prosecutions brought relying on the EPA 1990. And my view is that that's due to a combination of changes to cost recoverability in personal injury and the spectre of fixed costs being raised in the housing disrepair market. If you look in the handout, I've set out the types of nuisance that are expressly defined in section 79 of the EPA. They're there through A to K, and K, helpfully, is any other matter declared by an enactment to be a statutory nuisance. I'm sure you'll be disappointed to know I'm not going to go through all the statutes on the book and define each individual statutory nuisance. By far and away, the most common grounds that we see in these types of prosecutions is section 79(1)(a), premises in such a state as to be prejudicial to health or a nuisance. The other nuisances are used, but they tend to be used by local authorities for enforcement purposes rather than the other way around. So this talk's largely going to focus on prejudicial to health and a nuisance. The phrasing of section 79(1)(a) is quite deliberate. It requires you, if you are a complainant, to prove either that conditions are prejudicial to health or a nuisance. You don't need to establish both in order for your complaint to succeed. And as we'll go on to discuss, there's a very specific reason for that. Dealing first with conditions that are prejudicial to health. Prejudicial to health is specifically defined in section 79(7) of the Act as being conditions which are injurious or likely to cause injury to health. That is, on the face of it, a very broad definition that could encompass a wide range of things. But there has, as you'll see from the handout, been a series of appellate decisions that have attempted to narrow the scope of that broad definition. The first of those is Coventry Council and Cartwright, which is a 1975 divisional court decision. What was said in that case was that whilst it was recognised that prejudicial to health was a very broad scope of things, the purpose of the legislation was to target threats to health in the sense of disease, vermin, or other such things like that. Coventry and Cartwright was a case where a complaint was brought relying on the fact that there was constantly broken glass lying around an estate, and that posed a physical threat to the residents. The divisional court there found that the broken glass wasn't sufficient to be prejudicial to health because it didn't target what the legislation was looking at. Similarly, the Court of Appeal dealt with this in the case of the Crown on behalf of Everett and Bristol City Council, which is a 1999 case. This confirmed the earlier jurisprudence in Coventry and Cartwright, and they again reiterated the target of this legislation is disease rather than physical injury. So in Everett, the complaint was brought on the basis that a particular block of flats had a very steep and dangerous staircase, which a number of residents had fallen down and injured themselves on. And it was found in the proceedings that this staircase was liable to cause accidents. What the Court of Appeal said, again, was that that was the preserve of personal injury claims, and the purpose of the specific legislation under the EPA was to prevent against disease and protect health in that way. The test for whether certain conditions are prejudicial to health or not is an objective one. This is particularly important for defendants. I've had cases where we've had complainants argue that because of the particular health conditions of occupants in their household, the condition within the property posed a threat to their health. As was confirmed in Cunningham and Birmingham City Council, the court cannot take into account individual circumstances. It has to look on an objective basis whether conditions are prejudicial or not. In Cunningham and Birmingham Council, it was argued that a particular feature of a kitchen made it dangerous for the tenant's autistic child. And what the court rejected in that case was that the child's autism ought to be taken into account when assessing whether or not conditions were prejudicial to health. An important case when dealing with prejudicial to health cases is Southwark London Borough Council and Simpson. What Simpson said, and is of particular importance, is that the court is not entitled, and it will be an error for them to form a view as to the conditions of a property and their impact on health in the absence of expert evidence, or alternatively in rejection of unanimous expert evidence. So the court cannot say, in the face of expert evidence to the contrary, we disagree with you, we don't like the condition this house is in, and we find it is prejudicial to health. Whilst the case law has said that relevant professional experience is not confined to medical professionals, and you can have evidence from either environmental officers or, in certain cases, building inspectors, what Simpson also confirmed is that courts should disregard the opinions of those individuals who have no relevant expertise. An argument that I've often run on behalf of defendants is when, like in a disrepair claim, you have a complainant who comes along with a building surveyor who has no expertise at all in relation to environmental health matters, they are not a relevant expert and have no relevant expertise for deciding whether or not a particular building or the condition of a building is prejudicial to health. What it goes to, and we'll come on to talk about this when we talk to the tactics of a trial, go through the expert's CV very carefully, because you might often find that there is surprise lurking in there that you can use to your advantage. Moving on then from prejudicial to health to nuisance, the Supreme Court case of Lawrence and Fenn Tigers provided what I would say is a very good working definition of nuisance, in which it was said that nuisance is where conditions go beyond what objectively a normal person would find it reasonable to have to put up with. This is important for for people who represent both complainants and defendants, is that quite frequently nuisance and the concept of nuisance is used erroneously by complainants to complain about the state of their own property. The case law authority, National Coal Board and Thorne, makes clear that when you are relying on the conditions of the property being a nuisance, you cannot rely on that nuisance if it is your own property. You can only rely on that if you are a neighbour or other individual affected by the conditions of a certain person's premises. If you're relying on the conditions within your own property, a statutory nuisance doesn't arise unless you can prove that that nuisance is prejudicial to health. Moving on then to notice, and I say at the start, notice and the response to notice is where the majority of these cases are going to be won and lost at trial. It is crucial that if you are a complainant, you get the notice right, and if you are a defendant, you receive it, acknowledge it, and respond to it properly and promptly. The vast majority of these cases are won and lost on how somebody responds to notice. It's the first step in issuing a private prosecution, and it is a mandatory requirement for the prosecution for you to have brought an effective notice before laying the information, issuing the summons. For a prejudicial to health or nuisance case, the minimum period of notice you have to give is 21 days. Notice, if you're the complainant, normally must be served on the person responsible for the alleged nuisance. save in a couple of specific circumstances. Number one, where the nuisance arises from a structural defect in the property, notice has to be served on the owner of the premises. Second example is where the person responsible for the nuisance cannot be found, located, or identified, then the notice again has to be served on the owner of the premises. If your service is defective and you serve on the wrong person as a complainant, your claim should fail at the first hurdle. There's no prescribed format for the notice set out in the statute, but having said that, there's various case law decisions that say the notice still has to be sufficiently clear. So it has to be clear what you are complaining about specifically. I've been involved in cases where the complainant has come a cropper, where they've complained about rat infestation in a property, and in fact at trial it turned out to be a mouse infestation. The expert identified it as a mouse infestation, and there was the defendant was acquitted on the basis that they can't have been in breach in the notice, even though it may well have been the case that there was a problem with mice in the property. So you have to say specifically what is wrong, what you intend to do if the nuisance is not abated. And by that, I mean that you have to say, if you don't abate this nuisance within the set time period, then there will be a prosecution issued. And you have to say the time limit within the nuisance to be abated. As I say, for these prejudicial to health cases, it's 21 days. What you don't have to do in a nuisance case under Section 82 is, unlike in other statutory nuisance cases, you don't have to say what steps might be required to abate the nuisance. If you were a local authority issuing an abatement notice, the provisions within the EPA, it's a requirement of your notice that you say, at least in general terms, what steps you expect somebody to take to abate the nuisance. In these sorts of cases, particularly in cases where it's prejudicial to health, there's no requirement for you to do that. That was confirmed in the divisional court case of East Stafford Borough Council and Fairleas. Moving on then to the proceedings themselves, this process starts where the notice has either been ignored or the complainant's of the view that there hasn't been a satisfactory response. Where that is the case, the complainant then has to apply for a summons in the magistrate's court. In most of the case law, this will be, and other practitioner texts, this process is referred to as the laying of information. You probably already know, but if you don't, these proceedings are criminal in nature, even though they're quasi-civil, and so they require matters to be proven with the criminal burden and to the criminal standard. So the complainant has the burden to prove everything, and they have to do so beyond all reasonable doubt. The important thing to note once proceedings start is that for the purposes of Section 82, an offence will only be committed if the complainant can prove at the date of trial that the nuisance was in existence, or if it stopped, it was likely. For the purposes of the conviction and the nuisance order that the magistrates will make, the key date is the date of trial. If you have a multi-day trial or an adjourned trial, it is the first day that the trial was listed and started. There's a different requirement for costs, which I'll come on to deal with later on. But for the purposes of the conviction, the important date is the date of trial. The magistrates' court's got the power, if they find that the nuisance is in existence at the date of trial, to make an order requiring the defendant to abate the nuisance within a specific period of time, including ordering any works that it thinks is necessary for that purpose. It can fine a defendant up to level 5 on the standard scale if the nuisance relates to a property where the purpose of that property is human habitation, and the magistrate's court is of the view that the nuisance is such that the property is no longer fit for human habitation. It can make an order preventing human habitation within that property until such time as the nuisance is resolved. Obviously, that will be relevant for most of these prejudicial to health and nuisance cases. And it's worth bearing in mind that in those circumstances, if the property is deemed unfit for human habitation, the bill for finding alternative accommodation while the work is done is overwhelmingly likely to fall on the defendant. There's no set statutory defence available to a defendant, but I've set out in the handout, and I'll take you through now, what have been widely regarded through jurisprudence to be defences that are available to a defendant in these prosecutions. The first is that the notice given was not sufficiently detailed. As I say, important to be specific as to what the nuisance is that you're complaining about. There are several divisional court decisions where magistrates' court decisions have been upheld, where a prosecution has been thrown out because the notice just says the conditions within the property are prejudicial to health. You have to go beyond that, and you have to be more specific. Second one, notice not served on the right person. This can arise in two circumstances. Firstly, that the notice requirements that I'd set out earlier in this talk haven't been met, or occasionally, if there is more than one person responsible for the nuisance, or there's a dispute as to who is the person responsible for the nuisance, it can often be fatal to a complaint if you as defendant can allege somebody else is the person responsible and I shouldn't have been served with the notice. Third, complainant is not a person aggrieved by the existence of a statutory nuisance. It's fairly self-explanatory. That's effectively arguing that the nuisance doesn't exist at the property. Fourth, as I say, defendant is not the person responsible for the nuisance. And fifth, the nuisance alleged in the complaint doesn't exist at the date of trial and isn't likely to recur. Unfortunately, in relation to these claims, or these complaints, the defence of best practicable means is not available to defendant landlords. It's slightly unusual because for most other proceedings involving abatement notices, best practicable means is available as a defence. And ironically, if you are convicted and the magistrates make a nuisance order against you, and you are in breach of that nuisance order, you can bring a best practicable means defence against not complying with the magistrate's nuisance order. It's a strange lacuna. There has been some limited first instance authority in which a DJ sitting in South Lakeland's mags said you can't consider defences to this claim without looking at best practicable means, but the statute expressly prevents it from being considered as a defence. So in my view, for what it's worth, is that don't rely on BPM, or don't think you're going to be able to rely on BPM if a complaint is brought against you. The other important case to consider in relation to this is Warner and the London Borough of Lambeth Council, in which is a 1984 divisional court case. The defendant will avoid conviction if the court is satisfied that they are not the person by whose act, default, or sufferance the nuisance arises or continues. Now, in practical terms, that is number 4 in the list that I've argued. Defendant is not the person responsible for the nuisance. Where that can often arise is if you are landlord and can show there is no, for example, in the case of a rodent infestation, there is no structural defect or other defect within the property that is your responsibility that will allow the rodents to gain access, you can argue, relying on Warner, that you are not the person by whose act, default, or sufferance has caused the nuisance. Many of these tactics you will be familiar with from disrepair litigation. In truth, a number of these trials are disrepair trials being held in the magistrate's court. And the same things that you find useful in disrepair cases, and you're probably tired of people like me saying to you that these are useful in disrepair cases, or saying to your clients that this is what you need to be doing in disrepair cases, apply in this case. It's often invaluable if you're trying to demonstrate that there is no existence of a nuisance, if your records can show that prior to the receipt of the notice, there haven't been complaints by the complainant about the particular nuisance that they are complaining of. Frequent inspections, and what I've set out in the handout, and I cannot emphasize enough, is if you are faced with one of these prosecutions, carrying out an inspection on the property as close to the trial date as possible. There is no better evidence that will help you, particularly on the criminal standard, than having an experienced surveyor or inspector going out to the property in the week or days even leading up to the trial and saying, I've carried out an inspection, as far as I can see, the nuisance is abated, and if possible, getting the complainant to sign something saying this inspection has been carried out and this is the conclusion that's been drawn. As with most disrepair cases, appropriate expert evidence is key. This goes back to what I was talking about earlier in terms of making sure you have an expert with the relevant expertise. I have seen trials that have come a cropper both for claimants and defendants as a result of experts who either don't have the expertise that they say that they have, or otherwise get their evidence disastrously wrong. You want to, if possible, if you're having a trial, you want to be making sure that for your own expert, you're getting them in, you're making sure they know their report, and asking them, ideally with a conference or something else, putting to them the tough questions so you know that they'll be fine in cross-examination. Lastly, and this goes back to where I say that most of these cases are won and lost in the notice stage. If there is a nuisance there, you have to deal with it promptly and get your clients to deal with it promptly. You'll see why in a moment that is, because it might not put you in difficulty. It might not put you in difficulty in terms of a conviction, the prompt remedial action, as long as you get it sorted before trial, but it may well get you in trouble in relation to costs. And so moving on now to deal with costs. The main attraction to a number of solicitors who are bringing these proceedings under Section 82 of the EPA is the relatively advantageous position in relation to costs. There is very little adverse cost risks to a complainant, and there is a significant cost risk to defendants. In the handout, I've set out what 82.12 says, which is if the complainant can establish that at the time of issuing the summons, there was a nuisance in existence at the property, regardless of whether they secure a conviction, they are entitled to their reasonable costs. Because you're in the magistrate's court and because it's the Wild West, you'll find that often your costs assessments for complainant cost bills are far more generously dealt with than if you're in front of a DJ, a DDJ, or a circuit judge. Similarly, if you are defendant and you successfully defend, good luck getting your costs back, frankly. It tends to be a wasted costs type argument, even in circumstances where I've been of the view this was a prosecution that should never have been brought.